Go ahead and begin in 5, 4, 3, 2, 1.
This Honorable Court of Appeals of Tennessee is now in session.
Good morning. I'm Judge Neil McBrayer, and on behalf of Judge Arnold Golden and Judge Kenny Armstrong, I welcome you to this oral argument. We're going to conduct this argument in much the same fashion as we would if we were all together in the courtroom. Mr. Akers, there will be 15 minutes per side. Of that 15 minutes, you can reserve up to 5 minutes for your rebuttal time to respond to the arguments of opposing counsel, the appellee's counsel. How much time would you like to reserve for rebuttal, sir?
Respectfully, I really was planning to reserve 10 minutes for rebuttal, and you only use 5 minutes opening. Is that not acceptable?
It is not. So under our rules, you may only reserve up to 5 minutes.
Okay, then 10 minutes and 5 minutes, please.
All right. So your request for 5 minute rebuttal time is granted. The timer will be set for 10 minutes. If there are no preliminary matters, I'll ask Mr. Hibner to call the case, please.
James G. Akers versus Dyck-O'Neal, Inc. et al.
Mr. Akers, we will hear for you as the appellant.
First, let me apologize for making so much trouble. I've never done this before, and I'm old, so I'm trying to do the best I can. This case really comes down to a very simple matter, and that is whether Dyck-O'Neal and others, Dyck-O'Neal and their clan, have any lawful claim to my property whatsoever. And that is proven to be that they don't. Mr. Roan continues with his technical arguments to try to evade that, but all I sought really in my complaint or my petition was for a temporary restraining order, and then for the opportunity to proceed with a petition for a declaratory judgment. The Chancellor Perkins denied emphatically for me to proceed with a declaratory judgment hearing, and instead held a non-evidentiary hearing, and that put me at great disadvantage. So in the long run, Mr. Roan's firm presented a affidavit by Ms. Ori O'Neill, who's with Dyck-O'Neal, and stating that she was in possession of the electronic version of the original of the note.
Mr. Akers,
well,
Mr. Akers, can you hear
yes,
me?
I can.
Let me ask you before you get too far down this road. The only relief sought in the complaint that you filed was to enjoin the foreclosure sale. Is that correct?
No, sir. I also asked for a declaratory judgment.
In regard to what?
In regard to the issue of whether they had any lawful claims to my property.
Okay. Now, since the decision in the trial court, have you paid off that note that subject your property to a foreclosure sale?
Yes, sir. They forced us to right after Chancellor Perkins rescinded his restraining order. They proceeded right straight ahead with the foreclosure proceedings, and we were forced to pay them $77,000, which was $43,000 to Dyck-O'Neal and $33,000 to Mr. Roan's firm.
And then you got a release of that second mortgage. Is that right?
None of it. Well, no. All some I don't know what chaotic releases, and some can't even be read. But under Texas law and Tennessee law, Texas law especially, they're required to return the original of the note stamped. And the reason they haven't is because they can't. They never had to begin with. All they ever had was an electronic version of the original, which is, I have that. The Registered Deeds Office has that. Probably doesn't more other people have it. Doesn't mean they're entitled to enforce it.
Yeah. Was a release, Mr. Akers, was a release filed with the register releasing that second mortgage on your property?
Not satisfactorily, no.
When you say
No.
not, what does that mean? Not satisfactorily.
Means that paper is cheap. But what I'm saying is, I'm entitled, if we paid that mortgage off, debt off, so-called debt off, we're entitled to the original of that note returned to us, stamped, paid in full. That's under Texas law and Tennessee law. And we never received either one.
Okay.
If they had said that, go ahead.
The relief sought in your lawsuit was to enjoin the foreclosure sale. Is that right?
That's correct. And to avoid paying the $43,000 to Dyck-O'Neal, which they were never entitled to begin with, and then after they found out that we had the house, had offer on the house, then Mr. Rohn's firm added $33,000 worth of $34,000 of attorney fees. So we got the double whammy there, and we didn't owe either one. They were not entitled to either one.
Well, the reason there were attorney fees involved is because you didn't pay the note. Now, I know you dispute who owned the note, but there was a note that you were required to pay that you didn't pay, that you stopped paying years before they sought to foreclose. Isn't that right?
Yeah, sort of, yes. But
I'm sorry, was that a yes? That you stopped paying the second mortgage? I mean, you can dispute who you should have paid it to, but you stopped.
We were of the impression it was that second mortgage was supposed to have been extinguished by Morgan Stanley back in 2009, or National City Bank. We did a modification with both, and that under the HAMP guidelines required the second mortgage to be extinguished. Now, let me explain more of a thing here. It's not as though I tried to avoid the debt. I offered on at least a dozen occasions to pay them that debt, and was prepared to pay them that debt. The only thing I asked for was I want the original of the note back, and they refused it. The reason they refused to do it is because they didn't have it. They simply didn't have it. They still don't have it.
In your lawsuit, as your relief, did you pray for the return of the original note, or did you simply pray to stop the foreclosure?
I prayed for an injunction to stop the foreclosure, and then for an evidentiary hearing to determine and show to the court that they had no right to collect that mortgage at all, and they never did, and they still don't, but they did.
Now, in that you paid off the second mortgage, can this party now foreclose on your property?
No, they did not foreclose because we paid them off the day before.
So what's left to be decided, Mr. Akers?
Okay, primarily, the primary issue here is Chancellor Perkins made a statement in his order, his final order, stating that Dyck-O'Neal was in possession of the note and were entitled to enforce the note. That's just simply not true. That's based upon his understanding or his acceptance of an affidavit, which is fraudulent as can be, that said, and basically just all they had was the electronic version of the original note, and that's not acceptable. We knew that, so I have that. You can go get that yourself today, but doesn't mean that when the note's paid off under Texas law, where they're located, they are required to return that note, mark stamped, paid in full. They didn't. Under Tennessee law, they have not done it either. So the note is still here. We paid it off. We have a so-called release, but they never were entitled to begin with. Period. It was all a sham.
So the note has been paid, and you have a release. Is that right?
I have a release, and they have $77,000 of my money that they're not entitled to.
Mr. Akers, Dyck-O'Neal, is that the only entity that you're requesting the declaratory judgment relief against? What about the other two named defendants here?
The other two, well, they dismissed I can't remember the name, but this one was dismissed without prejudice. That was the collection agency, basically the auctioneers or the substitute trustee. So Chancellor Perkins dismiss them with prejudice, but I'm only concerned with Dyck-O'Neal and with Mr. Rome's company, who they collected $33,000. It was extortion. Very simply, it's extortion.
So really the only parties here we need to be concerned about on the appellee side then is the purported note holder and then the law firm.
The so-called recorded note holder, yes, and the law firm. It's my position they extorted $77,135 from us, and I can prove that if I just had an evidentiary hearing.
But now, Mr. Akers, in the issues raised in your appeal, you don't raise an issue about the dismissal as to the law firm or the trustee, did you?
I'm sorry, will you please say that again, sir?
As to the law firm and the trustee, the dismissal granted by the trial court, you did not raise that as an issue on appeal.
No, because it hadn't happened yet. That they had not collected that money at the time that the appeal was filed. Now there have been some documents filed since then, but at the time the appeal was filed, the time that my brief was filed, they hadn't been successful in extortion of the money yet. Now they have. They extorted that money back in December of last year, and they've absolutely refused to provide that original note now for over 12 years. Because they never had to begin with. This is fraud, plain and simple fraud. And no, I mean, go ahead.
Oh, I was going to say, Mr. Akers, your time has expired. I want to ask if there's any other questions from the panel before we hear from the appellees.
No.
Thank you, Mr. Akers. You'll have your time for rebuttal. Mr. Roan for the appellees.
Thank you, Your Honors. May it please the court, John Roan on behalf of appellees Dyck-O'Neal Incorporated, Aldrich Pite LLP, and Clear Recon LLC. Your Honors, as a preliminary matter, before we address the relevant facts and issues before this honorable court, we'd respectfully note that the appellant's brief fails to cite any applicable standard of review as required by Tennessee Rule of Appellate Procedure 27A7B, that it contains no relevant precedent, and that it cites virtually no facts from the record in support of his alleged issues. Therefore, it's respectfully our position that he's waived any argument regarding same. In Smith v. Hughes, cited in our brief and decided by this honorable court in May, the court made clear that it's not the role of the trial or appellate courts to research or construct the litigant's arguments for him, and where a party fails to develop arguments in support of his contentions or merely constructs a skeletal argument, the issue is waived. Accordingly, it's our position that none of the alleged issues raised are properly before the court and that they have all been waived. That being said, we'll now turn our attention to the relevant facts and issues involved in this case. This is an appeal from a final order, which we'll refer to as the appealed order, entered by the Chancery Court of Davidson County, Tennessee, which we'll refer to as the trial court, whereby Aldrich Pite and Dyck-O'Neal's joint motion for judgment on the pleadings was granted pursuant to Tennessee Rule of Civil Procedure 12.03, thereby resulting in their dismissal with prejudice. The appealed order also granted Clear Recon's motion to dismiss without prejudice pursuant to Tennessee Code 35-5-116C. The appealed order further clarified that the appellant's complaint was barred by the doctrines of res judicata, collateral estoppel, lack of privity of contract, and lack of standing. For all of these reasons set forth in our brief, we aver that the trial court did not err in issuing the appealed order and that the judgment of the trial court should be affirmed on appeal. This case is not the first time the appellant has tried to raise or litigate these issues. As established by the timeline of litigation referenced in our brief, the appellant and his wife have a history of alternating as plaintiffs, attempting to navigate between different state and federal venues and make the same arguments in efforts to delay foreclosure. Due to time limitations, and as it's our understanding that your honors have read our brief, we'll attempt to focus on the facts most germane to the issues involved on appeal. On April 16th of 2020, the appellant filed a petition with the trial court seeking an injunction to prevent foreclosure. A restraining order was issued with a hearing initially scheduled for April 29th, 2020, which was ultimately continued to August 28th of that year. In their response materials, the appellees asserted that the appellant failed to establish the requirements for obtaining extraordinary relief, and that his claims were barred by the doctrines of res judicata, collateral estoppel, and lack of standing. They also an affidavit from Dyck-O'Neal establishing that Dyck is in physical possession of the original note, providing a copy of same, and that it is the owner and holder of the note in due course. On August 13th and 14th of 2020, the appellants filed their respective answers with the trial court, all asserting several affirmative defenses, including res judicata, collateral estoppel, failure to state a claim for which relief can be granted, and the lack of appellant standing, as well as lack of privity of contract and a lack of adequate remedy at law. Aldridge Pite also asserted in its answer that it was not a necessary party, as no claims were made against it, and Clear Recon asserted in its answer that it was named solely in its capacity as substitute trustee, thereby entitling it to dismissal without prejudice at minimum pursuant to Tennessee Code 355116C. Thereafter, a hearing regarding the temporary injunction was held on August 28, 2020, with an order subsequently entered by the trial court on August 31st, wherein the trial court determined that the temporary restraining order, terminated the temporary restraining order and made certain findings, including that the deed of trust was ultimately assigned to Dyck-O'Neal, that Dyck-O'Neal was the owner and holder in due course of the related note, that the appellant previously made similar claims in Davidson County Circuit Court case 19C1390, in which several defendants, including Dyck-O'Neal, were dismissed without prejudice, that the appellant did not show a likelihood of success on the merits, that the appellant did not show an imminent risk of irreparable harm sufficient to warrant issuance of a further temporary injunction, and that the balancing of harms in the public interest militated in favor of the appellees. The appellant never appealed or otherwise challenged this order. He only subsequently commented on his disappointment regarding its entry. The trial court also entered a scheduling order on August 31st, 2020, which, among other things, provided for a deadline of March 19th, 2021 to file motions for judgments on the pleadings, and an October 2nd, 2020 deadline for filing motions to amend or supplement the pleadings. The plaintiff failed to do so. Aldridge Pite and Dyck-O'Neal filed a joint motion for judgment on the pleadings and memorandum in support pursuant to Tennessee Rule of Civil Procedure 12.03 on November 6, 2020. Therein, they asserted, among other things, that there are no claims for relief other than injunctive relief, which was denied by order of the court on August 31st, 2020, that the appellant's claims were.
No, Mr. Roan, you disagree with Mr. Akers' characterization of the relief he was requesting, that he was asking for in addition to injunctive relief.
That is correct.
Judgment.
That is, my apologies. That is correct, Your Honor. He only requested an injunction preventing foreclosure. He had until October 2nd to amend or supplement his pleadings, and he failed to do so. Secondly, getting back to our argument, the appellant's claims were barred by the doctrines of res judicata and collateral estoppel. In light of the order entered by the Circuit Court on October 14th, 2019, granting Dyck-O'Neal's motion to dismiss.
And is that order final?
The October 14th, 2019 order?
Yeah, the Circuit Court order.
Yes, Your Honor, that is our understanding, and we would further address that. Mr. Akers has another ongoing appeal, and we, of that case, of a subsequent order, which we'll address momentarily. But yes, it's our position, and we'll address that momentarily, that order became final 30 days after entry. But the order
on appeal, Mr. Roan?
The order on appeal in the other case is an August 28th, 2020 order, which was entered approximately 11 months after the order dismissing Dyck-O'Neal with prejudice in the Circuit Court case.
All right. Now, in that appeal, is Dyck-O'Neal a party to that appeal, or is it the other parties that were named as defendants in that Circuit Court lawsuit?
Dyck-O'Neal, Your Honor.
Is also, okay.
They are only.
Say it again.
Essentially, getting back to our argument, in the motion for judgment on the pleadings, parties asserted that there's no claim for relief in the complaint other than injunctive relief, which was denied by order of the court on August 31st, that the appellant's claims were barred by the doctrines of res judicata and collateral estoppel in light of the order entered by the Circuit Court on October 14th, 2019, granting Dyck-O'Neal's motion to dismiss. The facts that paragraphs 14A through N of the appellant's Circuit Court complaint were virtually identical to paragraphs 11A through F of his trial court petition, A through S of his trial court petition, and because res judicata bars issues which were or could have been raised in the prior litigation. 3, that the appellant failed to state a claim for which relief can be granted because there were no stated claims against the appellees, the alleged facts did not entitle the appellant to any relief, and the petition was entirely lacking in clarity and specificity. 4, that the assignments of the deed of trust are immaterial as the mortgage follows the note in Tennessee, and Dyck-O'Neal has established that it's the owner and holder of the note in due course. And 5, that the appellant lacks standing to raise challenges pertaining to the loan documentation as he was not an obligated party on the subject mortgage, an obligated borrower, thereby lacking privity, and was not a party to any assignment of the deed of trust. Clear Recon also filed its motion to dismiss a memorandum in support on November 6th, pursuant to Tennessee Rule of Civil Procedure 12.02, sub 6, and Tennessee Code 35.5.116C, based on the lack of any claims against them, the failure of the appellant to file any verified response to their answer, as required by Tennessee Code 35.5.116B, and the failure of the appellant to state a claim upon which relief can be granted. A hearing was held on December 4th, with the appealed order entered on December 18th, 2020. As noted in our brief, the ultimate issues on appeal are A, whether the trial court erred in granting the motion for judgment on the pleadings of Dyck-O'Neal and Aldridge Pite, and B, whether they erred in granting the motion to dismiss Clear Recon. Motions for judgment on the pleadings and motions to dismiss are essentially reviewed under the same standards on appeal. The court must take the factual allegations in the complaint as true and review the trial court's legal conclusions de novo, and the court should grant a motion to dismiss only when it appears that the plaintiff can prove no set of facts in support of its claim that would entitle it to relief. In assessing the issue of res judicata, the trial court noted in the appealed order that res judicata bars a second suit between the same parties or their privies in the same cause of action with respect to all issues which were or could have been litigated in the former suit. They further noted that 1, the October 14th, 2019 Circuit Court order granting Dyck-O'Neal's motion to dismiss was rendered by a court of competent jurisdiction. 2, the appellant circuit court complaint involved the same parties, since Aldridge Pite and Clear Recon were only named in the present action due to their status as foreclosure counsel and substitute trustee for the purpose of seeking injunctive relief. 3, the appellant's prior circuit court complaint and the petition in the present case assert the same claims. 4, the October 14th, 2019 Circuit Court order dismissed the case on the merits. And 5, the October 14th, 2019 Circuit Court order is a final judgment. And 6, the October 14th, 2019 Circuit Court order was properly entered. As this fulfills the requirements for establishing the affirmative defense of res judicata, as indicated in the Jackson v. Smith opinion cited in our brief, this was clearly not erroneous. More specifically, those requirements are that the underlying judgment was rendered by a court of competent jurisdiction, that the same parties or their privies were involved in both suits, that the same claim or cause of action was asserted in both suits, and that the underlying judgment was final on the merits. In assessing the issue of collateral estoppel, the trial court noted that this...
Mr. Ron, would you address mootness? Is this case moot?
That is our position. It has already been litigated. It has already been adjudicated.
No, I'm not talking about res judicata. I'm talking about, is it moot? The note was paid. A release has been filed. Is that true?
Yes. The lien has been paid in full. A release of lien has been recorded, and effectively, the issues would be moot, but for Mr. Akers' continued baseless accusations.
Well, Mr. Ron, hold on a second. I thought you said the only relief you requested in this was an injunction.
Correct.
So why are we worried about the accusations then?
Just the mischaracterization and attempted malignment unnecessarily of my clients.
So you're saying that we need to vindicate the court's findings on your client being a holder in due course, or I mean, what relief can we potentially grant in a case like this?
Simply to affirm the judgment on appeal, to affirm the judgment of the appealed order. That's what we're seeking today, that there's been no legal error. Your Honors, in assessing the issue of collateral estoppel, the trial court noted that this is essentially an extension of res judicata that bars a second suit between the same parties and their privies in a different cause of action as to issues which are actually litigated and determined in the former suit. Citing Beatty versus McGraw, also in our brief, the trial court indicated that the party invoking same must demonstrate, one, that the issue sought to be precluded is identical to the issue decided in the earlier suit. Two, the issue sought to be precluded was actually litigated and decided on the merits in the earlier suit. Three, that the judgment in the earlier suit has become final. And four, that the party against whom collateral estoppel is asserted was a party or is in privity with the party.
Let me make sure we're clear on some of these factual issues. Does your client hold a note that it can use to foreclose on Mr. Akers' property?
They are in physical possession of the original note, but they can no longer foreclose as they have been paid in full and their lien has been released.
Okay.
Well, I'm
Can you-
confused. Why wouldn't the note have been returned then to Mr. Akers or whoever paid the note?
It has not been returned because of the ongoing litigation. But we have provided a copy to him, color copy, stamp paid in full. But those post-judgment facts go beyond the scope of the arguments raised on this appeal and the underlying allegations involved in the trial court.
So you're saying we shouldn't consider the fact that the note has been paid off because it's a post-judgment fact?
To the extent that that moots some of the issues, possibly, yes. But however, the issue on appeal is whether the trial court erred in issuing its final order, and it's our position that they did not. But the trial court, I'm sorry.
Do we have a case in controversy? The only relief sought was to stop a foreclosure. Now, your client can't foreclose.
That is correct.
It's been paid. The mortgage has been released. Are you asking us to go through an exercise like that for no reason at all?
We're merely reiterating that the trial court did not err in issuing its final order. We would also stand on the issues and facts all raised in our brief. And as we're running out of time, if we could just briefly address a couple of issues that Mr. Akers raised on appeal. He continues to go beyond the scope of his own pleadings and brief.
Mr. Rohn, your time has expired. I'll ask the panel if there are any other questions of Mr. Rohn.
No.
All right, seeing none from the panel, we'll now hear from Mr. Akers on rebuttal. Mr. Akers, you have 5 minutes for your rebuttal.
The petition was filed back in June 21st of 2019, not 2020, as Mr. Ronan said there. He's got his years wrong there. It's entitled Verified Complaint, which it was, and notarized, Petition for Declaratory Judgments and Application for Injunctive Relief. The application for injunctive relief was granted and then withdrawn it rescinded like 5 months later, but the petition for declaratory judgment was never allowed to proceed.
Yeah.
And
Mr. Akers, do you have your brief there in front of you?
I do.
Can you go to page 7 of your brief?
Page 7, okay.
Yeah.
Okay.
That first paragraph.
Right.
Do you see what you say in your brief about the only relief sought?
Well, yeah, but I also say down at the bottom too, any and all other relief. And I think that's what would have entitled me to a petition for declaratory judgment. And
declare what? Declare what, Mr. Akers? What is it that you want us to declare?
I expected to have a evidentiary hearing, not evidentiary hearing, but an evidentiary hearing to determine if Dyck-O'Neal had any claims to my property whatsoever. That would have been a simple matter. If you have the original note, bring it. So far, all we have is their word that they have it. That's all we've ever had, going all the way back to 2009. They don't have that note. Anybody, like I said, I have electronic versions of the original. He has electronic versions of the original probably, and the registered deed has electronic versions. Electronic versions don't count. There are dozens of those out there. I am entitled to the original returned to me, stamped, paid in full, and they refuse to do it because they can't. This whole thing has been a fraud from the very beginning. Very beginning. Now,
Mr. Akers, are you even a party to that note?
Sir?
Are you a party?
I am signatory to the deed of trust, which supports that note. Yes.
No, that's not what I was asking you. Are you
Absolutely.
a signatory to the note itself? Was that a loan made by you?
It was made by my wife, but I also witnessed her signature, and
Mr. Akers, are you telling us then your opinion is, or your position is that you're liable on the note that your wife signed?
That's exactly correct. Absolutely.
So
And
they
as proof of that, they found my property. And may I say one more thing? I purchased by quick claim deed all my interest, my wife's interest in that property, including all the encumbrances, back in May of 2015. Now that was done for two reasons. One is the U.S. District Court said I didn't have standing. Next door neighbors trying to steal part of our property, so I thought, well, I'll just go ahead and buy. So now, if they can buy, if Dyck-O'Neal can go ahead and buy a $37,000 note for $10, and I go ahead and buy $43,000 debt for $1,000, which one is more egregious? They don't have the original of that note. I can assure you they do not have the original note. And if they did, tell them to produce it. One simple question. And I'm reminded of the movie Amadeus. One of his symphonies. You displace one note, and the whole work falls. This is one of those cases. If you did, it comes right down to, do they have the original of that note, or do they not? They do not have it, and if they did, why haven't they produced it after they've been asking for it for 11, 12 years? They don't have it. This is fraud, outright fraud. Period. Now, simply, if they would produce the note, you honors, this court could tell them, if you have the note, produce it, the original of it. You know what? They can't. I've offered to pay them a full at least 6 times if they could, and they're ready to take the money. But when it came down to producing the note, we can't do that. We can't do that. They don't have the note. This is fraud, outright fraud. And I'm going to say one more thing. I'm probably going to get in trouble for her, but I'm going to say it anyway. Mr. Rohn is very, very gifted. I know that. I understand. I recognize that. And it's not, and all respect, this is probably called what they call good lawyering. But you know what? I'm about the same age as you guys there. Where I come from, they call that as accessory after the fact and obstruction of justice. Now, which one is it? To me, that's what it is. It is, except they're being an accessory after the fact. They added $33,000 attorney fees because we knew we had to pay them or lose our home.
Right,
they knew that.
Mr. Akers, your time for rebuttal has expired. The case is submitted. I thank you both for your briefing and your arguments. Mr. Hivner, if you will recess us, please, until 1 p.m.
This honorable court is now in recess until 1 p.m.
All right, I thank